both Professor Scott Cummings and Kimberly Atkins Stohr's bio are available to you in the chat. I just want to add about both of them with respect to what I've learned from our preparation for this. These are people who are so incredibly dedicated to our country and to protecting the rule of law and democracy. Professor Cummings' work and research, which you'll hear about today, his teaching gives us hope for the future, as does the remarkable, insightful communication skills for Kimberly Atkins Stohr, who is also a lawyer and broadcaster, co-host of a podcast. So we're thrilled that we have this talent available for this important topic. I want to thank UCLA and particularly Jeffrey Wong for his support and patience and help as we work through the piecing together of this program. And I also want to thank my colleagues at Lawyers Defending American Democracy. We are a very small organization, but we are a very dedicated group of lawyers who are committed to galvanizing the legal profession to step up and do more to protect the rule of law. I hope you'll visit our website at LDAD.org and see all of the work that we have accomplished, that we and we will commit to the fact that we are going to continue accomplishing this work, and where we do this every single day to protect democracy and the rule of law as best we can, and hope you will join us in this effort. And now it is my pleasure to turn this program over to Professor Cummings and to Kim. Thank you.
Thank you so much, Lauren, for that introduction. And it's an honor for me to be in conversation with Scott Cummings about what happens when it's lawyers who attack the rule of law. Hi, Scott.
Hi, Kim. Thank you so much for doing this. And just let me also add my thanks to Lawyers Defending American Democracy for such great work defending American democracy and for being the catalyst for this conversation. I really appreciate it and feel very honored.
So we only have an hour and we can talk for a lot longer than that. So let's jump right in to the piece you wrote, both of the pieces you wrote, the longer article and the essay. You know, in reading it, I think to myself, well, lawyers aren't exactly the most beloved profession to begin with. You know, our history is replete with lawyers doing things that either in real time or certainly in retrospect look quite unethical, whether it's defending the institution of slavery or Jim Crow laws, or whether it was Watergate or other things. So why is what is happening now, in your view, different than the role lawyers have always played, even in the darkest moments in our history?
Thank you. That's a great question, and one that I get frequently when I talk about this work. And I think maybe I would answer it by just taking one step back and telling you a little bit about how I got to this point of studying lawyers who attack the rule of law. And then what I do think is different about the current moment and the current style of lawyering we're seeing. I spent my career studying lawyers in support of what I would call progressive, pro-inclusionary democratic movements, and really thinking about how lawyers could make our democracy better, and documenting the work that they did to do that. And I think historically, people who study lawyers have always thought of lawyers as having this crucial democratic role, and kind of didn't think too much about lawyers in this more attacking mode that maybe we have seen more saliently over the last few years. And then 2020 came, and I became very interested in this alternative mode of lawyers attacking the rule of law and thinking about what motivated them to do that, and in fact what was different about what we've seen before. And I think you illustrate some really good examples, and people often ask about the lawyers aren't the best messengers based on the sort of historical track record. But I think what we're seeing now is unlike what we've seen in at least a half a century, for a couple of different reasons that I'd like to just spotlight, and then maybe we can have a fuller conversation about them. I think if we look at what has happened in the 2020 election and what's happened, I think, with increasing momentum afterwards, there are really three elements of this sort of new wave of what I would call far-right lawyering that I think are particularly troublesome and different in kind. One, I think, is that it's characterized by this idea of total individual loyalty to really one person, and that person is Donald Trump. I think older kind of sort of conservative, mainstream conservative lawyering was institutionalist at some level, and it didn't really espouse a total individual loyalty. But I think what we're seeing now is different in that respect. I think two other elements are really important to spotlight. One is a willingness to embrace deeply misleading facts, outright lies, and conspiracies in the service of legal arguments. I think this is a really important element of the kind of lawyering that we're seeing coming out of 2020 that has been gaining momentum. And these arguments that are being supported by misleading and outright facts and outright falsehoods are really directed toward radical, unprecedented, and anti-institutionalist ideas that really seek to upend long-settled democratic values and institutions. So I do think it's sort of directing legal arguments at some of the cornerstones of American democracy in ways that do look and feel different than the kind of bad lawyering that we might have seen before that I think is really at issue here.
So what are some of the causes of this shift that you're describing, that the fact that it is more often lawyers who are willing to act in this way, in such an open way, frankly, than what we've seen in the past?
I mean, I think it's really complicated, but there are a couple of big factors at play in kind of shaping what I think of as the kind of radicalization of a certain element of the conservative legal movement. And I want to say that the sort of radicalization idea and the kind of lawyering that is anti-democratic, anti-rule of law, and we can talk a little bit about what those ideas mean, is politically asymmetrical in the sense that this is, in the United States at least, a story about the right wing of the legal profession and the right wing of politics for the most part. I think for the most part. That's not the case elsewhere in the world, but it is the case in the United States. So I think we need to start there and think about the factors that have really radicalized some elements of the conservative legal movement to sort of jump the track from the mainstream where a lot of them, most of them, all of them started into this other category that, as I've suggested, is willing to make false statements in the service of these really radical anti-establishment ideas. And so one of the big factors is just that so I think the legal profession is not immune from these external political shifts and is really shaped by them in profound ways. And so as U.S. politics has gotten more extreme and more hyperpolarized, it really makes sense that some lawyers are going to get pulled out to the very margins and make decisions to align themselves with extremist forces for a variety of different reasons. Some of them ideological, some of them maybe instrumental. I do think, again, there's sort of an interesting conservative legal movement story here where the conservative legal movement that started in the 1980s to kind of contest liberal progressive public interest law and American constitutionalism really formed itself in a way that, for the most part, over the last 40 years, has been within the normal bounds of constitutional conflict. Right? They made policy arguments that were antithetical to progressive causes, but they were not sort of outside the boundaries of constitutional conflict. But as far-right politics took over, they got some of them moved over into further far-right categories. And so I think part of it is you have ambitious conservative lawyers. They want to work in government. They want to work in justice. At the Office of Legal Counsel, and you have to make a choice when you have far-right forces taking over the party, and the pipeline is going to privilege that kind of legal approach. That there's some that have jumped over in that bound. So I think it's partly a story of shifts in politics that have incentivized some lawyers to go with the shifts and to kind of go all in on far-right political movements. And then I think the other shift that has enabled this to happen in some ways, I mentioned, the kind of characteristic of this kind of lawyering as being one in which lawyers are really reaching for misinformation, disinformation as kind of a cornerstone of the argument that they're making, is the availability of that kind of information online. And so I think technology shifts and social media trends have really created the kind of sort of the brew in which a lot of these ideas have been inculcated, and it's very easy for lawyers that want to make these radical arguments. They're going to reach for these outlandish ideas and try to normalize them as a legitimate form of legal activism.
No, I want to dig a little deeper in the point that you make, which is an important one, is that we are seeing this happening in a very lopsided way. These sort of attacks are coming from one end of the ideological spectrum. And, as lawyers, as I have known, we fully understand since law school that there are different ideological schools in the legal community or more like a continuum, right? And that's where you had groups like the Federalist Society or the Heritage Foundation form on one side and the American Constitution Society form on the other, sort of a battle of these ideological ideals. But that sort of has aligned now with the political spectrum. And as that has gone farther and farther to the extreme, particularly on the right side, the law has followed them. And we've sort of seen, I have a column coming out tomorrow about election-related lawsuits that are being filed, but it seems that battle lines are sort of drawn by Republicans and their lawyers trying to make it harder for people to vote or easier to contest the results of the election even before the election has happened. And people on the Democrat side, including their lawyers, trying to expand access to the polls. So how does the ideological divide, which is supposed to be about how we look at the Constitution, spill into that political spectrum? Or how has it, talk more about how it has spilled into that political spectrum?
Well, I mean, there are a couple of interesting, I think, foundational ideas and kind of experiences that have spilled into that political dimension, as you put it. One is that, on this issue of elections and voting and voter fraud, coming out of the 2000 election, which was the last big contested election where there was a Supreme Court decision that essentially decided in favor of George Bush, the voter fraud movement emerged out of right-wing politics with the idea of ensuring election integrity. And there was some legitimate concerns that movement had, but it kind of metastasized over the past 20 years in a way that really moved more beyond the facts, right? Beyond evidence that voting fraud is a real problem. And so this is the sort of shifting dynamics of evidence and social movement becoming radicalized. I think there's a legitimate basis that emerges, but then it gets moved into these far right corners when it becomes radicalized around ideas that are associated with more extreme leaders. So there's sort of always a residue or a foundation of kind of legitimate contestation over facts and policy that then, when the moment is ripe, and I think this is the other factor that's really important to emphasize and discuss, that these foundations they don't necessarily go in any particular radical direction. It really does take leadership that's willing to push them to these extremes. And then the idea is lawyers have a choice, right? Lawyers can go to the extremes with the leaders who are claiming that there was election fraud when there isn't any, or they can stand up. And I think 2020 saw both of those things happen in really important ways. But the split that it created, which you just alluded to, in the conservative movement between kind of rule of law, conservative legal thinkers and lawyers, and ones who are now aligning themselves with the kind of MAGA movement and Project 2025 pipelines. I think that's the dynamic, right? That's the way that these splits happen, and then they get channeled into government politics.
Yeah, I think on that point, talking about how that spillover happens, I'm reminded in the Supreme Court ruling that made it more difficult to bring Section 2 challenges under the Voting Rights Act, justices during the oral argument, I believe in the opinion as well, Justices Alito and Thomas actually were repeating some of those conservative talking points, saying, well, isn't there a compelling interest to eliminate voter fraud when there was not even evidence of voter fraud in the case? And you could sort of see the politics spilling over. But we've been talking about 2020 as if, that's a particular flashpoint in this in this discussion that we're having. Talk a little bit more about what happened leading up to 2020 and how that really changed the ability or the willingness of more attorneys to really go the route of attacking the rule of law around elections.
I mean, the 2020 experience is really interesting. And again, it sort of walking back a couple of steps in it. When Trump was first elected, I think it's fair to say that he made a bargain with the mainstream conservative legal movement. If you look at the folks that were involved in kind of populating his administration at the outset with conservative lawyers in the White House counsel's office and at the head of the DOJ, these were mainstream conservative movement lawyers. They were from Kirkland and Ellis, Jones and Day. They were elites within the conservative legal movement. And that was the kind of normal process that had emerged since the 1980s to provide legal talent to conservative Republican administrations. From the very outset, we can remember that that was a very, very fraught relationship between Trump and the mainstream conservatives. He basically fired his first attorney general because he authorized the special counsel on the Russian investigation. He almost fired Don McGahn, his White House counsel, when McGahn refused to fire the special counsel. And then he essentially decided to contract out and around his government gatekeepers. And so very early on in his administration, you remember, he hired Rudy Giuliani as his personal lawyer. Giuliani famously or infamously represented him in Ukraine, leading to his first impeachment. But there was already tension built in between Trump and the mainstream legal movement. He then privatized essentially counsel. And this is important leading into 2020 because there was already division and already an established conduit by which Trump could access private legal counsel. And if we think about what happened in 2020, I think the simplified version of the story is essentially the election attack occurred through the vehicle of private outside counsel, and those private outside counsel then ran headlong into the government lawyers who were in the White House and DOJ, who ultimately stopped this from happening, but it was by a razor's edge.
And I know we're going to talk about more of this as we continue this conversation, but the first thing I think of, well, what I thought of as I was covering these events happening in real time, as well as what I think of right now, just talking to you, is as somebody who was a member of the bar, to me, I was very careful in how I did everything, including the way that I practice law, but even in other things about the way that I presented myself in public, even because I knew it was important as a member of the bar to keep my license and to stay in good standing, to act in a certain way and to not do unethical things. That was a guardrail for me, even if I were inclined, which I don't think I would have been, to do something like this. Where are or were the guardrails in place for these attorneys that allowed them to feel so empowered that they could really lodge this full-scale attack on the rule of law right before all of our eyes?
I mean, this is the $64,000 question to some degree. The guardrails.
Oops, it looks like we may have lost Scott for just one moment. You will try to get him back. Just hang on tight. While we wait for Scott Cummings to rejoin us, I'm going to bring into the conversation Scott Harshbarger, who I know has a lot to say about this subject, including what guardrails exist or should exist for lawyers when it comes to protecting the rule of law. Scott?
Yes. I mean, I was intrigued by what Scott was going to say about your question about what happened to the guardrails. which has been to me the shocking reality of the last decade. In fact, that's why we sort of mobilized Lawyers Defending American Democracy, because the silence of the established bar in the face of a very clear assault on the rule of law, right in public, right before our eyes, the silence was deafening. The reality is, with all due respect to people around, the American Bar Association, leaders of law firms, deans of law schools said nothing, and actually consciously said nothing because they were concerned about criticisms that would occur from others, that they were being partisan. That's what shocked me, Kimberly, about so much of this, that the core principles here to me were not Republican or Democrat, liberal or conservative. They were core legal principles that all of us theoretically were taught in law school if we did not understand them as citizens. And the reality was that the established bar did nothing. Now, there are reasons for that, there are precedents for that, but one of the challenges that we've tried to undertake with Lawyers Defending American Democracy was to push the disciplinary bodies to step up and say, no, just because it's a public issue and not a client directly involved in complaining, that this is where aspirationally all of our rules, we always say that. We lawyers stand for the rule of law. We stand for it on facts and not this kind of criticism. And I must say, this is where I dated myself on this, Kimberly, was because I recall as a young lawyer in the Watergate era, when exactly what you were describing was occurring. Yeah. In fact, the Justice Department was arguably the enemy at that point. But the profession said, no, we are an independent legal profession. We will stand for the rule of law, and you can't just politically act inappropriately. 50 years later, we sit here, and the reality was, until very recently, thanks in many respects to people like Lauren and many others in the American Bar Association, Judge, the judge and others who have spoken up now, the reality is the silence of the established bar was the answer to one of the questions that I was going to ask Scott would be, what do you say about the silence of the established bar? Not just that people were arguing back and forth, but in the face of Rudy Giuliani conduct that we all believed, at least if you're trying to teach ethics at law school, believed was clearly in violation of these rules. Why was the rest of the bar, the leaders of the bar, of law firms, deans and others, silent? And with that, we've taken Scott off his silence.
Yeah, I'm sorry for going radio silence. There was some sort of catastrophic technical glitch there, and now I'm back. These things happen. So in terms of the bar's response to 2020, I mean, I think it's interesting. I 100% agree that the bar, the established bar, the leaders of law schools didn't do enough. But I also think, looking back on it, one of the kind of silver linings of all of it, for me at least, as someone who has studied this topic and thought about legal ethics for a very long time, is that really for the first time in my lifetime, legal ethics was in the news. It was kind of a hot topic, and people were debating it. There were op-eds about what was going on. The organizations like Lawyers Defending American Democracy, other groups, the 65 Project came into the scene and really did an amazing job, I think, raising the profile of what bar associations do, which most people didn't really understand, what constraints lawyers were under with respect to legal ethics, which people didn't really understand. And people started to talk about that. And I think that was a profound shift in legal culture and political culture that was really very valuable, that came out of it. So there was not enough of that happening, but I think against the baseline of just general lack of awareness about what these concepts and ideas and institutions even were at the outset, there was some forward movement.
So, one important thing too is to get the public to understand it, right, Scott? I was actually on a commission for the ABA a few years back that included journalists like me in an effort to encourage a better public understanding of the importance of the rule of law. Because I think if you went up and walked up to someone on the street and says, why is the rule of law important to you? They probably really wouldn't even understand it. It was, do you mean following laws? Do you mean not breaking laws? But just the idea that particularly people who have sworn an oath to uphold the rule of law, do that, do what the law requires, protect it and not attack it, and why it's so important to have that. So rate my profession in their role and the job they've done in really making clear what was happening here.
Rate the profession and making clear. I think
be kind, but I mean it's important because for people to understand, ultimately this impacts votes and voters and how they think about it. And if they think there was absolutely nothing wrong with John Eastman trying to usurp the authority of the Department of Justice and go against it, if they think there was nothing wrong with Donald Trump trying to impose his own people in the DOJ to make it his own institution, if they, if we don't let them know that it's not okay for Project 2025 to take the FBI and put it under direct control of the White House so that the president has its own enforcement force in a way that the founders never imagined. It's up to us to tell them that, right?
Absolutely. I mean, I think one interesting point, just to go back a little bit, is just why did these lawyers do what they did, and why did the public let it happen to some degree? I think goes to the point of different audiences and the way that people consume their media information and their news, as it were. I think one of the interesting features of the 2020 campaign against the election was that the people that purported to lead it, the Giulianis, the Trump, Eastman, Jeffrey Clark, at least outwardly, they purported to follow the rule of law, right? Their argument essentially was that they weren't breaking law. They were actually perfecting law because law was not functioning at the level of election counting in a way that justified them kind of overriding the legal system. The courts weren't working. This was the narrative that was being put out, both through the lawsuits and in the media. So at some level, I think it's interesting just to note that although, of course, looking carefully at what all of them did, we find unethical and illegal conduct replete in their actions. Their forward-facing strategy was to say that this was actually all about the rule of law, and so I think at that level there was an intentional effort to sow distrust and to create confusion about what exactly was going on at that time in order to justify this emergency authority of Trump, which was, I'm going to stay in office even though I actually lost because that was the only way to restore law. And so I think that the lawyers were smart enough not to actually believe that. I mean, I truly don't think they actually believe that was true, but they had decided as a political matter to go in with this strategy for reasons that I think are speculative. I mean, I don't know exactly, but we could speculate what they are. But I think for that reason, they were willing to transgress these ethical norms that other lawyers would have followed, right? And do it for deeply political reasons.
So I want to talk about what has happened since 2020 and sort of break it up into two parts. What we have seen lawyers do in service of autocracy since then, and also talk about some of the guardrails we've seen put in place, also very often by lawyers, be it the changing of laws around how elections are carried out, be it lawyers, prominent lawyers like Judge Ludick speaking out very publicly, sort of break down on either side pro and anti-autocracy lawyers. What has happened since then?
Well, I think on the pro-autocracy lawyers, I mean, we can look at Project 2025 as kind of a roadmap that you've already alluded to for what autocratic lawyering would look like in the next Trump administration. And, you know, the basic point of Project 2025 is to capture the public bureaucracy and make it a tool for Trump to advance a whole range of policy initiatives, legal and illegal. And it's important to note that this idea of capturing the public bureaucracy, which includes agencies, but also importantly, it includes the Department of Justice, is a sort of is a quintessential autocratic legal strategy. So if you look at successful autocratic takeovers in places like Hungary, for example, right after the judiciary is captured, they go after the public bureaucracy and the lawyers within it in order to validate new laws that consolidate executive power. And so this is sort of classic autocratic legal move. And if you look at the details of Project 2025, it singles out White House counsel and Department of Justice lawyers for a massive transformation. Why does it do that? Because it is those lawyers who prevented the attempt by Trump and his allied lawyers from winning in 2020. And so it's interesting to kind of probe into the details. I think this is the imprints of this autocratic lawyer on that document. I think half of the authors are lawyers. The main conservative legal organizations are behind writing major parts of it. And it explicitly says, and this is sort of almost a quote, that with respect to White House counsel, it will no longer be a ground for cultivating elite white-shoed lawyers who want to go back into elite private practice, but rather it has to be an activist legal organization that advances the interest of its client, which is the president. And this is a very radical departure from the norms of institutionalism in White House counsel, which are supposed to represent the White House institutionally and not the individual who's sitting in the Oval Office. Similar with Department of Justice, it's about purging everyone who's been there for a long time who may not share the far-right loyalist ideology, and putting in place people who are willing to essentially do whatever it takes to advance policies that Trump has been very vocal about wanting to initiate, like prosecuting political enemies. Today in the New York Times, it says he wants to prosecute election workers in states that don't go for him. Talk about militarizing immigration enforcement, detaining people on mass scales, overriding asylum laws, prosecuting women for getting contraceptions. I mean, it's really radical stuff. And it requires, I think the important part is that it requires lawyers within justice to sign off, right? And so it's critical to be able to capture that institution, to get the lawyers to sign off on these plans. That's the way, by the way, that Trump is protected also under the recent immunity decision, because that decision made it very clear that any act that's official gains absolute immunity. And the court specifically said that if the president is running things through his lawyers at justice, that's an official act. So he needs people there who are going to be able to greenlight these really radical and arguably illegal policies. And that gives him immunity, but it also exposes the lawyers, I think, to ethical potential ethical discipline, which is the other side of the story. So that's the sort of autocratic side of the story. I think that's been the big push to populate the Justice Department and other bureaucratic agencies with lawyers who are willing to be on the far right. It's conflicted with this creation of the Society for the Rule of Law led by Michael Ludig, who was an outspoken DC Circuit Court judge who was instrumental really in also stopping the 2020 attack and is broken with the far right legal movement in really public ways and important ways. But they're, as far as I know, being excluded from the pipeline creation into the new Trump administration. Right, that group is no longer relevant for the Project 2025 initiative, and so there's an important public voice for rule of law values within the conservative legal movement, but they're not part of the game now and getting lawyers into the government if Trump wins.
So what Uh, have we seen in other lawyers, people in positions like our friend Scott Harshbarger used to hold in state attorney general's offices or others doing to sort of prevent the kind of attack on the rule of law that happened surrounding the 2020 election from being repeated in 2024? Or what can they do?
I mean, I think this is where we have to talk about the bar, because what you know, my own take on where we're at is that the bar, if Trump wins, is one of the few democratic institutions that can actually do something about the plan to populate the government with far right lawyers who are going to sign off on these really pernicious policies. And that's because the lawyers in government have to be members of the bar. And the bar has actually, different state bars have been quite active in bringing disciplinary cases against the 2020 lawyers. And I think importantly, extending the principles of legal ethics into the new domain of protecting democracy. This is not something that bars have really done in any way because we have never really been in this position. But I think if you look at the bar disciplinary proceedings, so bars are prosecuting lawyers who were involved in the 2020 attacks. Roughly 20 lawyers have been either disciplined or have pending disciplinary proceedings against them by their state bar. These include Rudy Giuliani, Sean Eastman, who's been recommended disbarred in California. Giuliani's been disbarred in New York. The recommendation for disbarral in DC. Jeffrey Clark has been recommended to be suspended in DC. Other lawyers involved, like Lynn Wood and Sidney Powell, has a pending prosecution in Texas. So the bar is working. And I think the positive story is that the results of these cases, which are very high stakes cases, very, very well prosecuted by state bar disciplinary counsel, resulting in really very thoughtful and wide ranging opinions about ethical responsibilities to democracy, I think, have set the standard for lawyer conduct in the next administration. Why is that important? It's important because these bars have regulatory authority to disable lawyers from doing the things that Trump will need them to do in order to advance an autocratic agenda. And so being able to say, hey, as a government lawyer, Jeffrey Clark was sanctioned for writing a letter that had contained false statements about the Department of Justice finding election fraud that justified supporting Trump's claims. You can't do that as a government lawyer. You can't make false statements in the service of attack on a rule of law institution like an election. And you actually will be sanctioned for doing that. That's an important signal to lawyers that are going into this pipeline, this 2025 pipeline. And beyond that, the bar actually has some regulatory tools that would enable it to disable lawyers in real time. The DC bar can actually suspend a lawyer without a full due process hearing if they think there's imminent public harm. And so the combination of the kind of enforcement tools that the bar has in place and these new legal principles that have been articulated relative to what lawyers owe democracy in these government positions, I think really means that there's a huge battle coming up and the bar will be at the center of it.
Do you think that's enough, Scott? I mean, the people that we're talking about, in many of them, the lawyers working in a private capacity, have either been charged in state court or named as unindicted co-conspirators in federal court with the attempt to overturn the 2020 election for their work. Do you think there needs to be, do you think that the discipline that is done by the bar licensors is enough to create the important guardrail that we see is needed here?
It's not enough, but it's something. And I guess the worry is that, you follow these criminal prosecutions as carefully as anyone in the world, and they have not generally gone the way one might have predicted when they were put in place. And obviously, if Trump wins, the federal ones are going to go away. And so I think that's the scenario in which I don't think the bar can do it by itself. There has to be popular mobilization. I mean, hopefully, obviously, the ultimate disciplinary tool is electoral accountability and electoral success for Trump's opponent not getting him in office. That's the ultimate sanction, obviously. But if that doesn't work, then the problem is these other tools that we would rely upon in a normally functioning democracy, right? These tools of criminal prosecution may not work the way we want them to, because they will have been captured to some degree by the very person that they're supposed to be directed against. And in that scenario, the bars are going to be one of the few independent players that haven't been captured and that would be able to actually push back. I think, again, this is not a sufficient condition for restoring and protecting the rule of law. There has to be popular mobilization, and there has to be continued public awareness campaigns. And so actors have to be willing to work together. I mean, I think the other thing that's really important to emphasize is just when we think again back, what can we learn from 2020 that's relevant to 2025 potentially? You know, the government lawyers actually did their job. The attempt now is to take them out of commission. Courts did their job, right? Courts also did their job ultimately. And so that's another really important thing to remember. Courts have to be working in concert with the bars, have to be working in concert with civil society organizations and popular mobilization to really all hands on deck.
What is the role, if any, of academia here? Because we're talking about groups. You know, when I was in law school, the Federalist Society was conservative, but it seemed that we all agreed that, for example, the process of nominating judges should happen through the executive and there shouldn't be litmus tests about how they would rule. But the Federalist Society led the way to Donald Trump's, list of conservative judges to install, which helped him get elected. Or you have the Heritage Foundation that has now morphed into a key proponent of Project 2025. These are groups that are supposed to be about conservative legal ideology, conservative construction of, originalists who read the plain text of statutes and the Constitution, and they've sort of turned into something else. Is there a role for academia to sort of rein that in and show that that is not what should be taught, and that is not the way that we should think about this legal ideology?
I mean, I think absolutely academia, law schools have to play a leadership role in this crisis. And, it's complicated from the point of view of these student organizations and their position relative to the outside political world. I mean, the law schools that, obviously law schools have been incubators for radical right-wing ideology, far right ideology. You'd think the vice presidential candidate of the United States went to Yale Law School and is now an avowed election denier and has made statements in public that suggest that if courts rule some of Trump's far right proposals illegal, that basically they shouldn't follow the rule of law. I mean, this is super dangerous stuff coming out of elite legal spaces in ways that really make one worried about the ability of the normal socializing processes within law school to keep lawyers within boundaries when the stakes are so politically high and there's so much to be gained for an ambitious Yale Law School lawyer to cross the line, right? To go over into this other side in terms of, and so I think that's the problem. Can law school and the profession keep these lawyers within guardrails when there's so much power, right? Potential power on the other side of that particular line. And, I'm not ultimately sure what the answer to that is. I think law school could do a lot more than it's doing now. I think speaking firmly and strongly and with clarity about what lawyers' obligations are to democracy and to truth. I think that's the other important thing that law schools are supposed to do, is to teach lawyers who are willing to argue about interpretation of law based on a common shared fact base, right? No one is supposed to reach for non-facts to make legal arguments. That's what we train lawyers to do. And so I think law school is really communicating an important message about we stand for truth first and foremost and make legal arguments within the boundaries of a zone of shared facts. But also then there are obligations to the system that actually really, really matter. Law schools don't do that well. I just don't think they do that well. Now is an opportunity to rethink the way we actually educate students so that it impacts them going forward. But what to do in the short term, I think, is still really a crisis point because partly it's become so politicized that it's sometimes a topic that law schools and law faculty shy away from because it's so explosive.
How big of an issue, you mentioned the immunity decision by the Supreme Court, which in itself was very divided, with fairly broad, in my opinion, immunity being granted to a president to perpetuate sort of the same autocratic practices that we've been talking about. And, a dissent that stated fear for democracy. How much has that fed into the enabling of this type of anti-rule of law lawyering to take place?
I think it has solidified a certain message that says if lawyers are on the inside of government in this Department of Justice, White House counsel spaces advising the president that their conduct immunizes, right? Their actions can immunize illegal action by the president. Because remember, the Supreme Court in that opinion said that discussions with lawyers in justice are presumptively immune and presidential intent doesn't matter, which is to say that the president can ask DOJ lawyers to prosecute opponents just because he doesn't like them, even though that's illegal. And he can't be prosecuted for that because his intent to prosecute them for bogus grounds doesn't actually matter. So I think it adds solidity to this idea that who gets to be positioned in those roles matters a lot. And the lawyers themselves, I think, importantly, are trying to extend the immunity decision to actually cover what they would do in their role advising the president on actions that would be arguably illegal. So if you look at Jeffrey Clark's DC bar opinion, where he is suspended for 2 years for his participation in the 2020 effort to put DOJ's imprimatur on the false election fraud claims, he makes an argument that the immunity decision actually bans the DC bar from sanctioning him because federal law is supreme. And if a lawyer in justice gives advice to a president on an issue that the president is deemed to be immune on, so are the lawyers, not just from criminal prosecution, but from actual bar discipline. And so the immunity decision is being mobilized by lawyers to actually unshackle them from bar regulatory oversight. And I think this is a really, really important issue that has kind of gone under the radar. But these lawyers are actually coming after the bar's power to regulate them and to discipline them for actions that are unethical and anti-democratic. And that's scary.
Wow. So, Scott, we've gone through a lot here. Before I bring General Harshbarger back into the conversation to close this up, what do you want those participating in this webinar to take away from the pieces that you wrote, and just sort of leave us with why you did this and why it's so important?
Well, I think I want people to come away with a sense of agency first and foremost. That the idea that we all can make a difference in our own ways. Because one of the things that I think is the most enduring lesson for me from the 2020 attacks is that it ultimately hinged on a few lawyers who were were willing to stand up for rule of law, democratic values, and to push back. And this kind of these sort of small efforts can actually make a big difference. And in a moment when there's so much at stake, the margins are actually very, very small. And so small actions of agency and democratic support can actually tilt things in the right direction. And so I want people to understand, what is at stake, how lawyers can support the rule of law, and how the legal profession, I think, has really admirably risen up to this challenge and really has asserted itself as one of the really important democratic institutions of our time.
All right, I want to bring Scott Harshbarger back to add some more views.
Well, first of all, thank you. I have the honor, Kimberly and Scott, of being the co-founder and chair of the board of Lawyers Defending American Democracy. And I just wanted to mention, as I had a chance to say briefly while Scott was immobilized technically, that when we started this at actually my 50th reunion at Harvard Law School, and realizing that so few lawyers had stood up to even raise the question about why it was a political issue to talk about due process, fairness, equal protection, the standard ethical issues that we took for granted. And the reality was they were being challenged, obviously and publicly, and established bar, many state attorneys general, many deans of law schools, big law, were silent. And the silence was deafening. And therefore, when the public was asked to comment, they weren't hearing from lawyers to talk about, which is why what you're saying is so important, Scott, about how people need to understand that legal ethics are a foundational principle in the rule of law, that lawyers being held accountable as an independent profession is important, but we also need to be accountable to not only adhere to the principles of confidentiality and client zealousness and those kind of things, but to uphold and protect and defend the Constitution and the rule of law. And that's been the role of Defending American Democracy. That's why we're so honored that you participated. We're so pleased as among the multitude of people who listen and read Ms. Stohr's regularly and her admirers. It's just great. I think that one of our challenges is what to do with this. And that's what Kimberly was raising and you're raising. What is the role? And this is where I go back, if you will, to my Common Cause days with John Gardner, reminding us that democracy is a spectator sport, that one person can make a difference. And it is little things that people do that can make a huge difference in how this comes out. So to some extent, this is on us as much as it is on the combatants here to stand up in a neutral way and decide this isn't about politics. This is about core principles, norms, and values that are enforced by democracy, not by enforcement or prosecutions. So I thank you for helping us lead this effort. I thank you for giving us an opportunity to be heard. But most importantly, understand to all those listening, I hope that you will join us. Many of you already have, but this is the time to be heard, to stand up, to preserve and protect democracy. We're also welcome, of course, your support and going to our website and seeing what we're doing and trying to do. But please join me now in thanking Scott Cummings for speaking truth to power, for Kimberly for repeatedly reminding those in power that there is truth and accountability out here, and to all of you as citizens to understand that we are responsible for our own destiny, and it is not about others, it's about us. So thank you so much, all of you, for joining us, and thank you too for participating.
Thank you.
Thank you.